Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
So a lot of y'all know trial isn't in today, but this past Friday, we talked a lot about plea deals going down, especially after Woody got absolutely annihilated by Max Shart in cross-examination. I had a feeling a lot more of these plea deals were going to be brought forward by the prosecution, just because so far it's not looking like they were prepared and able to handle this case as well as they thought they would. So we haven't heard anything about new plea deals yet, but I wanted to kind of rewind and talk about some of the plea deals that were presented or that were actually taken in the past, and specifically the plea deal that was given to Anthony Sledge, aka Montauk. Y'all have heard him mentioned in the past couple of weeks, and he also is on the witness list as well, so he may end up testifying here soon at some point. But I want to go ahead and get into his court proceedings and talk about what happened leading up to that. And then we're going to actually take a deep dive and look into what exactly was included in his plea deal, so y'all can see exactly how the state is crafting some of these plea deals and how they're pushing a lot of these defendants and co-defendants to testify against Young Thug. So check this out. This first video is when he was in court. He had spoken with his attorney, and then they're actually meeting and before the recused Judge Glanville, we'll put it that way. So y'all check it out. Let me know what you think, and let me know if the volume is good too.
All right, we're on the record in the matter of the state of Georgia versus Antonio Sledge in 22 SC 183572. Good afternoon, Mr. Wright.
Good afternoon, Judge.
Good afternoon, Mr. Sledge.
Hey, good morning, Kat.
And good afternoon, counsels Love and Hilton. Okay, counsels, I understand this is supposed to be a negotiated plea. Is that correct?
That's correct, Your Honor.
Yes, Judge.
All right, Mr. Sledge, can I get you to raise your right hand as best you're able?
Yes.
Do you solemnly swear or affirm that the evidence you shall give in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God, or so affirm?
Yes, I do.
All right, you put your hand down, sir. All right. Mr. Sledge, over the next several minutes, what's going to happen is we're going to go through such a thing called the providency inquiry. So basically, in our system of jurisprudence, we don't force people to plead guilty. So I have to be assured you understand your constitutional rights and that you freely and voluntarily waive those rights so I can go ahead and sentence you. The second thing it does is we go through a factual basis, and I determine if there's a factual basis that the state would have been able to prove in this case beyond a reasonable doubt had they tried the case. So assuming that I find that you understand your rights, we call it the Boykin inquiry. And then the second thing is, then I find that there's a factual basis I can accept your plea. So, ladies, which one of you is going to do the plea?
And y'all will notice too, as we go throughout this plea deal specifically, a lot of the guys who are mentioned in this RICO, it's unfortunate just because the reason many of them are taking the pleas is because they had either something silly like a possession of a firearm by a convicted felon, and then they lump that into the RICO conspiracy, kind of similar to what we heard with Lil Woody when he got picked up as he was playing basketball, which kind of spiraled everything out from there. So it's interesting to see how a lot of these guys are getting caught up in the same things, and you'll see that here in the Sledge case.
I am, Your Honor.
All right, Ms. Love is going to go and ask you a series of questions in just a minute, and then your attorney, Mr. Wright, will follow up with that, and then I'll ask you a couple of questions, and I should be able to sentence you in accordance with the negotiated plea. Okay?
Yes, sir.
Okay. All right. Ms. Love, whenever you're ready, madam.
Thank you, sir.
No, he took a plea deal. We'll talk about it.
Mr. Sledge, please state your true, correct, and legal name.
Antonio Sledge.
And are you the same Antonio Sledge, also known as Montauk, who is listed in indictment 22 SC 183572.
Yes, ma'am.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
Got Miss
No, ma'am.
Love up there.
How old are you and how far have you gone in school?
I'm 41, 10th grade.
Are you able to read, write,
grade.
and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses?
Yes, ma'am.
Conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act,
Yes, ma'am.
as well as possession of a firearm by a convicted felon,
Yes,
as
ma'am.
listed in count 30 of this indictment.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges, and that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney, Mr. Derek Wright, about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Do you waive a formal reading of the indictment?
Yes, ma'am.
Do you waive any and all defects in the indictment, including any with respect to your name?
Yes, ma'am.
Have you been arrested on these charges?
Yes, ma'am.
The state is unaware of any
go
outstanding
through
warrants
all this.
related to these charges. Do you, Mr. Wright, know of any outstanding warrants that are related to these charges?
I do not.
Mr. Sledge, has your attorney advised you of the minimum and maximum sentence for each charge that you are pleading guilty to
Yes,
today?
ma'am. Yes, ma'am.
Do you understand that the minimum sentence for conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act is 5 years and the maximum is 20 years in prison?
Yes, ma'am.
Do you understand that the sentence for violation of count 30 of this indictment, possession of a firearm by a convicted felon,
There's
as
your
in
possession.
OCGA 1611-133, is 15 years in prison?
Yes, ma'am.
15 years. We got to change some of this stuff. 15 years for possession of a firearm by a convicted felon. Did y'all know that? I know some of y'all in the chat know this and remember seeing this too. Whew. Crazy. Can you imagine, especially if it's not a violent crime?
Do you
15 years.
understand that this is a negotiated plea of guilty,
Yes, ma'am.
which means that the state will recommend to the court the following sentence?
Yes, ma'am.
As to count 1, 15 years to serve on probation, subject to the special conditions contained in the plea agreement that I have in my hand that I will show you in just a moment. And on count 30, although you are pleading guilty, sentencing will be withheld until the completion of the initial trial of this case. After the trial of this case,
That's
the initial
crazy.
trial of this case, provided defendant you have complied with the special conditions outlined in sections B, C, D, F, and I of section 3 special conditions of sentence of this plea agreement, the state agrees that the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. Do you understand that the court does not have to accept that recommendation? And we will read into the record the terms of the plea agreement in a moment.
He has a
Do you
copy.
understand
He saw
that?
it.
Yes, ma'am.
Do you understand that the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other if the court does not accept that negotiated plea?
Yes, ma'am.
Yep, so he had a gun and he was indicted on the RICO. Sheesh. What up, though, S. Dot? Thank you for
Do
your
you
service, John.
understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today, but that the state is not recommending either?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including in the federal courts?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea involves your being placed on probation, and that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence? Do you understand that?
Yes,
Got to
ma'am.
keep your nose clean.
Do you understand that you are not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice given to you by your attorney or anyone else?
Yes, ma'am.
Do you understand that if at any time you are sentenced to confinement based on this
Good morning, Mel.
sentence, neither the court, your attorney, nor the district attorney's office has anything to do with parole, and that in that circumstance, the Department of Corrections or Board of Pardons and Paroles
Yes, ma'am.
are the only persons who can address parole, and that no one can guarantee parole no matter what anyone has told you?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and your right or ability to obtain employment. Do you understand that these rights may be affected?
Yes, ma'am.
You know what this makes me think of, and we'll keep going through this in a minute. Y'all remember with Woody saying that the police put a gun on him? Think of how scary it is to have a felony. And no wonder Young Thug doesn't want a felony on his record. You get stopped by a police officer. And I'm not saying all cops are dirty, all cops are evil. There are good cops out there, there are bad cops, right? But you've got a felony. You get stopped by a police officer, or a police officer's having a bad day and they know you have a felony and they have a gun, which we know this is the case. Police officers having throwaways, or whatever term you want to use to call them, and they have a gun there. You get arrested. The police officer says, hey, there was a gun in the car, and this was the only person in the car, right? They were walking down the street and they had a gun in their pants, similar to what Lil Woody said. I mean, you're looking at 15 years? $15 This system is so messed up in so many ways, man. And that's something so simple. And a lot of these guys get caught up that way too. And even if you're not actually the one who has the weapon, there's someone near you. If you're in a car with somebody else who has a weapon, you can get in trouble for that too if you have a felony. It's crazy.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of another felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand
15
that you
years.
waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you would have the right to trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Good morning,
Yes,
Kirsty.
ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand that you are giving up all of these rights?
Yes, ma'am.
Thank you, Morris.
I'm showing you what has been marked as State's Exhibit 1AS. Do you recognize the document in State's Exhibit 1AS?
I mean, y'all understand you can get a felony for shoplifting? It's crazy. And thank you to Morris for showing love, man. I appreciate you. You can get a felony for shoplifting. And I think in Georgia, there's an amount limit. And we had a lot of cases like this when I was serving on the grand jury of people who were shoplifting. And then it was their first time and second time and third time. And then boom, you get hit with the felony charge. It's just crazy. Yeah, in Georgia, you can.
Yes, ma'am.
Right here in Fulton County.
And is that your signature on page 7 of 7 of State's Exhibit 1AS?
Yes, ma'am.
Mm-hmm.
Your Honor, at this time, actually, and Mr. Sledge, have you had an opportunity to review each and every provision within State's Exhibit 1AS?
Yes, ma'am.
As reflected on State's Exhibit 1AS, the current charges that you face are count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act.
Thank you, Kat.
And count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm, OCGA 16-11-133. The negotiated sentence as outlined in State's 1AS is count 1, 15 years on probation, and count 30, sentencing withheld until the completion of the initial trial of this case. After the initial trial of this case, provided defendant has complied with the special conditions outlined in section B as in boy, C as in Charlie, D as in Delta, F as in Frank, I as in Indigo of section 3 special conditions of sentence of this plea agreement, the state agrees that defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to null pros count 30. The special conditions of the sentence, as outlined in Section 3, are that defendant shall abide in full by each and all of the terms of this negotiated agreement. Defendant's failure to abide by any term of this agreement shall constitute a violation of the agreement. Defendant shall testify truthfully about all matters relating to this case upon which he is questioned at any trial or judicial proceeding stemming from the facts alleged in this indictment. In accordance with testifying truthfully about all matters relating to this case, defendant acknowledges that each and all of the statements contained within the defendant's factual acknowledgments section of this agreement are true. Defendant shall testify truthfully about each statement contained within defendant's factual acknowledgments and any matters related to this case when asked to do so in any proceeding related to the facts alleged in this indictment. Defendant shall possess no guns unless his right to do so is restored. Defendant shall commit no criminal acts. Defendant shall submit to random drug screenings by the Department of Community Supervision and any agency designated by the court in this case. Should the defendant test positive for any Schedule 1, 2, or 3 drug, defendant shall within 30 days of said positive test undergo drug rehabilitation as designated by the court or the Department of Community Supervision and shall successfully complete said rehabilitation program. Defendant relinquishes any Fifth Amendment right related to any statement contained within defendant's factual acknowledgments contained within this plea agreement. Section 4, defendant's factual acknowledgments. have you initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document?
Yes, ma'am.
And we're going to go through those here in a second, the factual things that he initialed. So we're going to go step by step, and I'm going to show y'all exactly what he agreed to. Well, let me rewind this real quick, and I want y'all to listen to what she said.
Initialed each and all of the defendant's factual acknowledgments contained within section 4 of this document.
Now, the factual acknowledgments are interesting. We talked about this when we were looking at Lil Woody's immunity deal and some of the things he was allowed to say and wasn't allowed to say. The factual acknowledgments y'all will see once we get into it are absolutely crazy. One of those things has to do with Big Nut. I'm sure y'all can guess exactly what that is. So Miss Love mentioned about him withdrawing his guilty plea. And I want to kind of explain to you what that would look like if he were to do that or why he would do that, right? So withdrawing a guilty plea in Georgia after taking a plea deal, it's a little bit complicated, but here's what would need to happen, right? So the timing, you can request to withdraw your guilty plea anytime before the judge officially sentences you. This is the easiest time to do it. Now, the sentencing, as y'all will see once we get further into this video, is going to take place right away in this instance. After sentencing, you can withdraw a guilty plea as well. If you've already been sentenced, withdrawing a guilty plea is much harder. You can file a motion to withdraw the guilty plea, usually within the same court that handled your case. You must show that there is a good reason for withdrawing your guilty plea, like not understanding the consequences of the plea, being pressured into it. Sound familiar? Or your rights being violated in some way. Maybe an ex parte meeting or two. I don't know. We won't get into that, though. Court decision. The judge will hold a hearing to consider your request. You'll need to present evidence supporting your reasons for wanting to withdraw the plea. The court has discretion to grant or deny the motion. If denied, you may appeal the decision, but appeals are also challenging and require strong legal grounds. It's highly advisable. This is all just crazy. It's just saying that you got to consult your legal representative or your attorney if you've been sentenced and you want to withdraw your guilty plea, which is interesting because those rules do not apply to immunity. And we saw this with Woody again. He didn't want the immunity. He didn't want to testify. And the state just said, here you go. Now you got to testify. It's crazy, man. Let's keep going, though.
Yeah,
and thank you
no.
to Kat.
And is that initial AS your initial?
Yes, ma'am.
The factual acknowledgments are as follows. Number 1, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include, but are not limited to, colors, hand signals, and terminology, who have committed crimes intended to increase the notoriety, street credibility, and reputation of YSL. Number 2, defendant has been a member and or associate of YSL since 2012. Number 3, while associated with YSL and to support and express loyalty to YSL, defendant and co-defendant Demekion Garlington and Quindarius Zachary appeared in a video with another person, AS, where defendant brandished a weapon used in a drive-by shooting, and where on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's ex-girlfriend. Number 4, on or about April 28, 2015, as reflected in Fulton County Indictment 15SC 138994, defendant and fellow YSL associates Demekion Garlington and Quindarius Zachary committed a drive-by shooting using the firearm defendant wielded in the video referenced in Part 3 of this section, targeting family members of a rival gang. Number 5, defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder.
Yep.
Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Number 10, defendant has personal knowledge that on January 10, 2015, after the murder of Donovan Thomas Jr., YSL associates traveled to Miami, Florida with co-defendant and YSL founder Jeffrey Williams, aka Young Thug.
Allegedly.
Number 11, defendant did not murder Donovan Thomas Jr. and was not a party to the crime. Number
Woo, that sounds familiar to y'all. Defendant did not. They love putting that in these immunity deals and these pleas. The defendant did not murder Donovan Thomas. Boy, they really want to get your boy Young Thug. Crazy.
12, defendant did not murder Shamel Drinks and was not a party to the crime. Number 13, defendant cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas Jr. are not guilty of the murder, and defendant will make no attempt at trial, prior to trial, or after trial to exonerate the persons charged in this indictment with the murder of Donovan Thomas Jr. Number 14, the gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and do not allow other gangs to operate. Number 15, the gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and do not permit other gangs to operate.
Exposing all the hubs.
Number 16, defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL: murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales.
Appreciate you,
Mr.
AM3.
Sledge, have you had an opportunity to go over each one of the defendant's factual acknowledgments and make corrections where necessary?
Yes.
And do you now acknowledge under oath that each of the factual acknowledgments that you have initialed in this section are true and correct and accurate to the best of your ability?
Yes, ma'am.
Part 5 of this plea agreement, Your Honor, states that defendant's sentencing acknowledgments are as follows. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, the district attorney can and will use the contents of this document and agreement during any judicial proceeding. Defendant understands fully that if he violates any provision or any special condition of this plea agreement, his probation for this sentence may be revoked in its entirety, and the district attorney will recommend that defendant serve any remaining portion of this sentence in confinement at the Georgia Department of Corrections or prison.
They don't lock his
Number 3,
ass
defendant
up.
understands fully that any violation of any provision or of any special condition of this plea agreement shall result in defendant being sentenced on count 30 of this indictment, and the district attorney will recommend that the defendant serve the maximum sentence allowed by law. Number 4, defendant understands fully that if prior to the conclusion of the initial trial of this case, defendant fails or refuses to testify to any fact that he acknowledges in this plea agreement, such failure or refusal nullifies any promise made by the district attorney to null pros count 30 of this indictment. Number 5, defendant understands fully that defendant's violation of any provision or of any special condition of this plea agreement prior to the conclusion of the initial trial of this case shall nullify any promise made by the district attorney to null pros count 30 of this indictment and may result in defendant being, and Your Honor, there is a typo that is in this document. It's the word should be being, and it's spelled B-E-G-I-N. I'm going to ask that defendant just strike through and initial that word, B-E-G-I-N to B-E-I-N-G.
There you go. Yeah, and shout out to Tim. He says, and people are calling Woody a rat. Sounds like this guy did more talking to the DA than Woody. Well, I mean, we have hours and hours and hours of interrogation or interview videos of Woody saying lots and lots of names and tell lots and lots of locations. So I don't know, man. I think Woody still takes the prize when it comes to talking to the police, but I'll let you have that one. And it's similar to what Gunner said too.
Above the strike through of the word began to change it to being.
Yes, ma'am.
Okay?
He said, Woody having sleepovers at the station. Oh, man. He had his hands. He had his hands. His chin on his hands like that. His feet back, kicked up, swinging his feet. So you guys want to know about YSL? Oh, can you pass the popcorn? Listen to this. Listen to this.
And may result in defendant being sentenced to serve as much as 35 years of confinement in the Georgia Department of Corrections or prison. Number 6, defendant understands fully that no promises, agreements, or conditions have been made other than those set forth in this document. Mr. Sledge, are these your initials on each section under defendant's sentencing acknowledgments?
Yes, ma'am.
Mr. Sledge, do you agree that the following statement is one that you have read, fully understood, and signed your name acknowledging? I, Antonio Sledge, have read and carefully reviewed this agreement. I have reviewed and corrected where necessary for accuracy each statement contained in defendant's factual acknowledgments, and I acknowledge the truth and accuracy of each and every statement listed therein. I fully understand this agreement, and I've had an opportunity to discuss this agreement and each of its provisions with my attorney, Mr. Derek Wright. No promises other than those contained in this document have been made to me in furtherance of this agreement. I freely, knowingly, and voluntarily enter into this agreement without force, threat, or coercion. Is that the statement that you acknowledged in this agreement?
Yeah, ma'am.
And is that the statement to which you signed your name underneath?
Yes, ma'am.
All right, so let's take a break here because I don't know how in the world the court reporter is catching all of this because Ms. Love went through them so quickly. So let's take a pause in this. We'll get to the sentencing here in a second and actually review what ADA Love was talking about. So check this out. This is State of Georgia versus Antonio Sledge, aka Monk Tonk. Up in here, current charges. Count 1, conspiracy to violate the Racketeering, Influence, and Corrupt Organizations Act, and count 30, possession of a firearm by a convicted felon previously convicted of a felony involving the use or possession of a firearm. So it's these 2 charges, which this one, oh man, it's crazy that it's even in there because they haven't proven that that's the case yet. But anyway, we'll keep it moving. Negotiated sentence. Here we go. Count 1, 15 years to serve on probation. We'll get to that in the video here in a second. And then count 30, sentencing withheld until the completion of the initial trial of this case. So he hasn't even been sentenced for this yet because we're waiting until we see what happens with the YSL trial. After the initial trial of this case, provided defendant has complied, I can read y'all, with the special conditions outlined in sections B, C, D, F, and I of section 3, special conditions of the sentence, the plea agreement, the state agrees the defendant shall be allowed to withdraw his guilty plea on count 30, and the state shall agree to count 30. All right. So we'll go through that here in a second. Special conditions of the sentence. And Ms. Love just went through all of this. Defendant shall abide in full by each and all the terms of this negotiated agreement. Defendant's failure to abide by any of the terms of the agreement shall constitute a violation of the agreement. All right. So we know all this. We've been through this before. Just make sure you do what you're going to say. And here's where he initialed everything. All right. These are the factual acknowledgments. These get interesting. In case y'all missed them when she read them, I want to go through them one more time. First off, Young Slime Life, aka YSL, is an organization made up of 3 or more members or associates who share common identifiers that include but are not limited to colors, hand signals, terminology. Sounds kind of like a YouTube channel, except we haven't committed crimes intended to increase the notoriety, street credibility, and reputation of the YouTube channel. All right. Yeah, hey, listen, y'all, please do not go out there committing crimes and throwing up. Oh, I can't be putting C's on the live stream and throwing up CBs on the live stream. What would it be? We'll do sign later. So we'll do the CBs up in here and say, yeah, ClassE Beats gang. Don't y'all do that. I'm not trying to get hit with a Rico. All right. So just chill, relax, and let's keep it moving. We'll have a good time here. And then that's it. Number 2, defendants have been a member / and or an associate of YSL since 2012. Okay. While associated with YSL and to support and express loyalty to YSL, defendant and co-defendants Demekion Garlington and Quandarius Zachary, that is, excuse me, that is appeared in the video with another person, Antonio Sledge, wherein defendants brandished a weapon used in a drive-by shooting, and wherein on behalf of YSL, defendant threatened to harm a person named Kel, a rival gang member who had begun a relationship with defendant's girlfriend. And Kel, we know that was Big Nut's brother who got into it with Lil Woody, right? And then number 4, on or about April 28, 2015, as reflected in the Fulton County indictment right here, defendants and fellow YSL associates Demekion Garlington and Quandarius Zachary committed a drive-by shooting using a firearm defendant wielded in the video referenced in part 3 of this section, targeting family members of a rival gang, which is interesting because Woody's talking about this right now and saying that he was the one who did it. What? It's kind of crazy. Don't know. Y'all stop it, man. Not CB gang. Don't do that. Nope. We are not CB gang. We're not doing that. Y'all don't go out there committing any crimes, throwing up the CBs. Okay. I'm going to say it was Chris Brown. Dang. Y'all don't do that to me. Number 5. Defendant and his fellow associates committed the drive-by shooting referenced in sections 3 and 4 on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Woody's saying he did this now, so it's going to be interesting to see what happens to Mr. Antonio Sledge as this trial goes along. Defendant admitted to committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in 3, 4, and 5 above. Defendant was told by another YSL associate that immediately after the murder of Donovan Thomas, YSL associates met at the McDonald's on Cleveland. Oh, how about some hearsay? We love hearsay, don't we? Defendant was told by another YSL associate. Jesus. Oh, man. After the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on the Cleveland Avenue in Atlanta, Georgia, to discuss the murder. So yeah, Mr. Antonio Sledge heard from somebody at the barbershop that this is what went down when Donovan Thomas was murdered. Yeah, can you just initial that right there for me? Defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas on behalf of YSL. I'd love to hear how he knows that. Maybe we'll get to that at one point. Number 9, on January 10th, 2015, after the murder of Donovan Thomas, defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low. Defendant has personal knowledge that on January 10th, 2015, after the murder of Donovan Thomas Jr., YSL associates traveled to Miami, Florida with co-defendant and YSL founder Jeffrey Williams, aka Young Thug. Defendant did not murder Donovan Thomas and was not a party to the crime. They keep trying to push this on everybody. I mean, we know who the state thinks did it, but there's a lot, especially after we heard that cross-examination from Max last Wednesday, that there's a lot of speculation as to who actually did it and who was involved, because it sounded like Thug didn't have anything to do with this, according to Max, but we'll see as we keep going on. Defendant did not murder Mr. Drinks and was not a party to the crime. Defendant cannot truthfully assert that the persons charged in this indictment with the murder of Donovan Thomas are not guilty of the murder. And defendant will make no attempt at trial, prior to trial, or after the trial to exonerate the persons charged in this indictment with the murder of Donovan Thomas. So he cannot say that one of the defendants did not kill Donovan Thomas. Number 14, the gas station at 151 Cleveland Avenue, Atlanta, Georgia, is one of multiple locations where YSL associates sell drugs and don't allow other gangs to operate. The gas station at 221 Cleveland Avenue, Atlanta, Georgia, is another location where YSL associates sell drugs and did not permit other gangs to operate. Defendant has personal knowledge that he and other members or associates of YSL have either participated in or directly committed at least one of the following crimes in order to increase the notoriety and reputation of YSL. Murder, armed robbery, aggravated assault, attempted murder, theft, illegal gun possession, and illegal drug possession and sales.